Very good morning, everyone. Welcome and thank you for joining us today at this webinar on mandatory reference checks and misconduct reporting regime. Okay, my name is Eunice Tan. I am a partner in the Financial Services Regulatory Practice Group of Baker McKenzie Singapore office. And with me today, I'm joined by my partners and colleagues, Grace Fung, a partner in our Financial Services Practice Group in the Hong Kong office, as well as Sonia Wong and Zhao from our Hong Kong and Singapore office in employment practice groups respectively. So as the title of the webinar invitation state, this seminar is about curbing rolling bad apples in the financial industry. As you all know, there is an increasing focus on culture, individual conduct, as well as individual accountability within the financial industry globally. And it's the same for Hong Kong and Singapore as well. In fact, I'm sure you would know also that the trends between the two key financial markets in Asia are certainly quite similar, often one following after the other or sometimes simultaneously. So for example, in Hong Kong, we saw the manager in charge regime took in effect sometime, I think 3 to 4 years ago. And in Singapore, we will be seeing a similar regime coming into force in September this year, which is in about a month's time. And recently, MAS has also announced and confirmed certain changes to the mandatory reference checks regime as part of MAS's larger focus on curbing rolling bad apples within the financial industry. And we also see similar developments in Hong Kong as well. So we thought, it would be timely to share the developments in this space in both countries. And for those with us today who are overseeing operations in both countries, hopefully you will be able to see a comparison between the two regimes at the end of the webinar today. So as set out in the agenda, we will be covering the mandatory reference checks regime in Singapore, followed by Hong Kong. We'll also talk briefly about the misconduct reporting regime and some changes in the works in both countries as well. And then lastly, we will round it off with sharing of some practical steps as well as other legal considerations that financial institutions should be mindful of as you prepare for the new regime. Okay, before we begin proper, just a few housekeeping notes. So this session will be recorded. The slides and recording of today's webinar will be available and provided in a follow-up communication after today's session. If you've got any questions throughout the webinar, please feel free to use the Q&A button at the bottom of the screen to submit your questions. We will do our best to address them as we go along the presentation or towards the end of the webinar if time permits. But we do have quite a bit to cover in this 1 hour session. So, if we are not able to address any of the questions, we do apologize in advance, but certainly happy for you to reach out to any of the speakers here today if you've got any follow-up questions after the webinar today. Okay, one more point to note, I guess, for the Hong Kong participants or those who are looking to claim CPD points. Please note that we have applied for 1 Hong Kong CPD point for this webinar. So if you wish to claim the CPD points of it, you will have to complete all 5 poll questions, which we will prompt periodically throughout the webinar. Do note that you have 45 seconds to answer each poll question. And if you're joining via browser and unable to access the polls feature, you can submit your answers through the chat function available on Zoom. Okay, so without further ado, let's turn to the very first polling question. Okay, so the question is, the hiring of employees in Hong Kong and Singapore by financial services company is currently subject to A, no mandatory requirements to do background checks, B, depending on the position, may be subject to fitness and propriety assessments under laws and regulations, and C, I don't know, please tell me. So the correct answer is B. Glad that most of you have answered that correctly. Of course, there are some nuances between the Hong Kong and the Singapore regime. So I think that brings us quite nicely into our very first session today, which is on the mandatory reference checks regime in Singapore. Next slide, please. Okay, I'll start off by just very quickly providing a recap of the existing reference checks regime before we talk about what's going to change going forward. So, as you know, under the existing regime, I'm sure you know that reference check is not a new concept at all. Currently, there are already requirements on reference checks, although I would say that the requirements are fairly generic in nature and also fairly dispersed, right? So if you look at, the current regime, essentially it's set out mainly in two circulars and guidelines, which we have set out on the slide. The first circular that applies to essentially CMS license holders, financial advisory firms, as well as exempt financial institutions like the banks, who appoint representatives under the SFA and FA to conduct regulated activities at financial advisory services. So as these relevant FIs, we do need to ensure that the representatives you hire are fit and proper. And in connection with that, MAS has also set out in the circular their expectations as to the due diligence that you need to carry out in ensuring fitness and propriety. Okay, so if you look at the guidelines, they are actually fairly generic, right? So it really just sets out that you should be doing checks on previous employers for any dismissal or adverse records, checking on the public register of representatives maintained by the MAS, and also conducting property searches on past regulatory records, as well as financial status of the individual. But quite apart from that, no specific look-back period that has been prescribed, nor any prescriptive list of information that you should be getting as part of the due diligence check. The other requirement, of course, is the guidelines on remuneration framework, and this one applies specifically to FA firms. If you're looking to hire or recruit financial advisors, there is a requirement for you to request for the last 4 balanced scorecard grades of the proposed hire. And of course, the receiving FA would also need to oblige when you do receive such request from another recruiting FA firm. But these requirements don't apply. Technically speaking, they don't apply if you are, for example, looking to hire someone who will only be serving one retail clients, for example. So that's an overview of the existing requirement. Now, what's going to change in future, right? Next slide, please. One more slide. Okay, so I've set out here an overview of what's going to change in future. Now, maybe just a couple of notes here. So you may recall that basically MAS initially consulted on this new regime sometime in July 2018. And then in May this year, MAS issued its response to the feedback received on the consultation paper. Okay, and basically in this response, MAS has more or less confirmed the changes that will be made to the mandatory reference checks regime, affecting SFA FA representatives as well as insurance broking staff. So it's limited to these pool of FIs and employees. Now, of course, on the same day also, MAS actually issued another set of consultation paper where they have proposed to extend this mandatory reference check regime to a wider pool of employees. So not just limiting it to representatives and insurance broking staff, but proposing to extend basically this new mandatory reference check regime to other employees as well. Now, this other consultation has closed, but the response to public feedback has not been issued by the MAS yet. So as of now, we don't quite know what the final amendments will be. We will be talking a little bit about this consultation paper very briefly later on. But for now, what I really want to focus on really is the changes that will more or less, that have been more or less finalized and will be implemented going forward, which are really the changes affecting SFA FA representatives as well as insurance broking staff. So a very quick overview on this new mandatory reference checks regime. So what you'll be looking at essentially is that going forward, there will be a universal set of mandatory reference checks requirements. This will be mandatory. So it's not just expectations that are set out in circulars or guidelines, but quite likely that it will basically be reflected in the revised MAS notice or perhaps in a new notice. But what's clear is that it will be a set of mandatory requirements. In terms of the reach of this regime, as I mentioned earlier, it will basically apply to financial institutions who appoint SFA FAA representatives or insurance broking staff. Okay. Apart from imposing a requirement on recruiting FIs to conduct their mandatory reference checks, MAS will be imposing a corresponding requirement on, receiving FIs. So basically, the present or past employers of representatives and broking staff to essentially respond to any mandatory reference checks request. So there's an obligation to obtain, and there's also an obligation to receive if you're at the receiving end of the financial institution. The other highlight of this new mandatory reference check regime is also that there will be a set of prescriptive baseline mandatory information that you will need to obtain or provide, depending on which side of the FI you are at, okay, which we'll be looking at in the next couple of slides. And then just a note in terms of timeline, I think as of now, MAS hasn't really announced any formal effective date for the new regime. It does look like they will also be maybe doing some final touches to those new mandatory reference checks after they have received feedback on the other consultation paper to extend this regime to a wider pool of employees. So there may be some final touches to this, the regime affecting representatives and working staff. But what I'll be sharing today are amendments that are more or less finalized and have been confirmed by the MAS. Next slide, please. Okay, so we have actually set out in the next, I think, 2 or 3 slides, a list of the mandatory baseline information that will need to be obtained or provided. I won't go through in details what these information are, which we've actually set this out exhaustively in the slide. So you can have a look at this after the webinar. But just very quickly, if you look at the slides, essentially, what the records that you will need to obtain or provide will essentially be on, the appointment history of the individual, right? Duration of appointment, their roles and responsibilities, their cessation of appointment and the reasons for the cessation. Compliance records, so that will be on any investigations carried out on the individual, any incidents resulting in any breach of legal or regulatory requirements, any disciplinary actions taken, any misconduct reports that were filed with the MAS against the individual, and then the last 4 balance scorecard grades, as well as persistency ratio of insurance policies sold by the individual. The last 2, of course, would apply to a specific group of employees in the FA or the insurance broking space. Okay, just maybe a few additional notes to highlight for the responding FIs. Okay, so you don't actually need to disclose investigations which were carried out on representatives if they were concluded in favor of the representatives. So that's some additional guidance that MAS has provided in the response to the consult paper. And then as a responding FI, if you do receive a request and there is an ongoing investigation taking place for that specific employee, MAS has said that you are expected to provide information if it's substantiated, unless, of course, there is a risk of any tipping off. So, for example, if the investigation relates to a potential offense under the CDSA, and that may, of course, result in a risk of tipping off, then you are exempted from providing the information to the recruiting FI. But short of that, you basically do have an obligation to provide the information to the requesting FI. Other guidance that MAS has provided are basically if there is an investigation by a foreign regulator, for example, and you are bound by any duty of confidence, then of course you don't need to provide that information to the recruiting FI. Next 2 slides, please. Sorry, 1 slide back. One more. Yeah, okay. So just a couple of additional notes as well for with respect to the duties of receiving FIs. Okay, do note that essentially, as I mentioned earlier, you will actually be mandated to respond to any reference checks that you receive. And the timeline to respond to those checks would be 21 days from the time you receive the request. MES has also provided some guidance in terms of the standards that you should be applying when responding to these reference checks requests. So for example, ensure that you provide true and accurate information, don't act with malice, exercise reasonable care when you prepare and communicate references, making sure that they're accurate, objective, clear, balanced, and based on verifiable facts. Don't selectively disclose information, and ensure that you do provide sufficient details so that a reasonable person can make an informed judgment about the nature and severity of the representative's adverse records. So unfortunately, MES has also said that they will not be granting any immunity for responding FIs, right? So responding FIs, you will not be absolved of any legal liability arising from the responses that you provide to the reference checks request. So I think it's quite important going forward for FIs to think about, making sure, basically verifying the reports that you do provide to requesting FIs, making sure that they do comply with the standards that MES has set out, and also being mindful of other potential legal risk that can arise from providing these reference checks. And on this point, my colleagues will actually be sharing some further guidance and also looking at the particular case law in Singapore, touching directly on this point around whether you owe any standards or duty of care towards the employee when you provide reference checks to future employers, which we'll cover at a later stage. So that's a little bit about the duties of receiving FIs. I think flipping back to the responding FI, I also just wanted to emphasize that do note that the reference checks requirements apply with respect to essentially any present or past employers of the proposed hire, right? So basically, there is also a look back period. Essentially, you would be looking at, you do need to conduct the reference checks for the last 5 years of employment, right? So if you're looking to hire someone today, you should be conducting the reference checks for the past 5 years. And we're talking about 5 calendar years here. So if, for example, there is a gap in the proposed hire's employment, you don't actually need to extend that 5-year period to cover 5 years of employment. We're talking really about the last 5 years of calendar years of the proposed hire. Now, whilst the obligation for receiving FI, of course, only applies to FIs regulated by MES, as a recruiting FI, basically the reference checks that you need to carry out, you would basically need to extend it to all present or past employers of the proposed hire, right? So it's not just looking and reaching out to employers, past employers who are regulated by MES, but basically any past employers of the proposed hire in Singapore or otherwise, regulated or otherwise. Now, of course, I mean, in cases where the past employers are not subject to the MES regulations or the corresponding requirements to respond to you, chances are you probably will get very little information from them. And that's fine. MES is not saying that, that means that you can't hire these hires. But basically, what that means is that you're still expected to carry out reasonable due diligence, obtain information from other available sources of information, and be able to demonstrate that you're satisfied yourself that the proposed hire is nevertheless fit and proper, notwithstanding a gap in information by virtue of the fact that you're not getting a corresponding set of information from past employers who are regulated by the MES. Okay, so just summing up on the mandatory reference checks very quickly, I think we'll cover a little bit more on this towards the last section of this webinar. But some practical steps to consider for financial institutions, really just to sum it up, I think we've kind of set out some of the practical steps that you need to consider, which I believe most of you probably already have some processes in place in relation to these items. But essentially, do ensure that your record-keeping policies with respect to HR and employees are updated, right? Because basically, you need to ensure that you do capture all the mandatory baseline information so that you stand ready to respond to these requests when you do receive a request from a recruiting FI. Okay. Secondly, do have to think about establishing, standards and processes, timelines, as well as identifying, the responsible persons who would be reviewing and approving these reference checks reports that you'll be releasing to the recruiting FIs, so that you can ensure that you do meet the standards expected by the MES, as well as be able to adequately manage any potential legal risk that your financial institution may be exposed to by providing these reference checks to the recruiting FIs. Notification and consents from employees from a PDPA perspective. Although I think generally speaking, if you are required to obtain this information pursuant to a legal requirement, then you would be exempted from the notification and consent requirements under PDPA. Although as a matter of good practice, I think a lot of financial institutions still do obtain these consents. Of course, for recruiting FIs, do ensure that you update your due diligence and filing process to capture these mandatory reference checks requirements. And then lastly, do preserve the right to withdraw or revoke any offers to new hires, which I think you already do. But I think one of the practical considerations here really is, I think it's quite common for potential hires to request for mandatory checks to be carried out only after they have been provided with an offer letter by you. Right. So what happens then? Do you actually have to conduct the reference checks before, or can you actually agree to the request of the proposed hire? Now, in this case, you can wait until the proposed hire has resigned or has terminated his current or her current employment. But in these instances, you are expected to actually take appropriate steps depending on the outcome of the subsequent reference checks that you carry out. So for example, if it turns out that there is adverse records, then basically you do need to, reevaluate and think about whether the individual is still fit and proper. And if it's not, then of course you are expected to withdraw that offer. Okay, now just moving on very quickly to the consultation on expanding the mandatory reference checks to a wider pool of employees. We have summarized these proposals in the next 3 slides, but I'm conscious of time, so I won't be going into details of these proposals. They are not being finalized as yet. So I think, just do keep a lookout for the MES's responses to these consultation. But just, a very quick summary, the gist of this consultation really is MES is looking to essentially expand these mandatory reference checks requirements to a wider pool of employees. So, what I've been speaking about, as mentioned earlier, they really apply to CMS license holders, FA firms, exam financial institutions who appoint SFA, FA representatives of insurance brokers. But what MES is looking to do is to actually impose the same mandatory reference checks requirements to almost all FIs that are regulated by MES, and also expanding it to not just SFA, FA reps and insurance brokers, but also to senior managers of financial institutions. And senior managers here would be essentially the same list of senior managers as you find in the upcoming individual accountability guidelines. And the other proposal that MES has set out is to also expand this requirement to employees undertaking risk functions. Right? So basically anyone who undertakes any roles for the financial institutions that may result in specified risk for the financial institution. Although MES is seeking feedback on whether this really should just be focused on financial risk or should be extended to a wider types of risk within the financial institutions. But in terms of the mandatory baseline requirements and timelines, they are pretty much, what MES has proposed is pretty much similar to what I've just explained in relation to representatives and voting staff. Okay, so with that, I have come to the end of the session on the mandatory reference checks regime for Singapore. Let me just, okay, we've actually received quite a number of questions. So I think we're a bit short of time here. So I will be handing over to my colleague, Grace, to talk about the Hong Kong regime. And then, and meanwhile, I'll be answering those questions on the chat box. Okay, sorry. Before we go on to the Hong Kong session, here is the second poll question. Okay, and the question is: does the new MRC regime, what does the new MRC regime in Hong Kong? Who will it apply to? A, all types of Hong Kong financial institutions. B, all new bank employees in Hong Kong, regardless of their position. And C, new employees of HKMA regulated AI. Depending on their position. Okay, well, the answers are fairly divided here. Maybe I think I will hand this over to my partner, Grace, to walk you through the Hong Kong regime.
Okay, thank you, Eunice. I'm Grace, and I partner in our financial services practice at Baker McKenzie. And for this session, we are going to speak about the Hong Kong regime on the existing reference checking regime in Hong Kong, as well as the proposed new regime that will take into effect. Next slide, please. Maybe let's briefly talk about the regulatory structure in Hong Kong, because unlike Singapore, we have different regulators regulating different service lines of different types of financial institutions. And accordingly, the due diligence or the fitness and properness assessment criteria could differ depending on the regulatory status of the different types of financial institution. So for banks in Hong Kong, they are regulated by the Hong Kong Monetary Authority, the Hong Kong MA, and there are a few key functions that are subject to fitness and properness requirements, in particular, the directors, chief executives, alternate chief executive managers, and if the banks are also conducting SFC regulated activities and are registered institutions, then also the executive officers or the relevant individuals will also be captured under the fitness and properness requirements. And for those entities which are conducting SFC regulated activities like securities brokers, financial advisors, and so on, they're regulated by the Securities and Futures Commission, and the roles and functions that are subject to fitness and properness requirements include those who are directors, responsible officers, licensed individuals, and so on. And then for insurance and MPF regulated financial intermediary, similarly, there are quite a number of different functions which are captured, like for insurance, the licensed technical representative and the responsible officers, and for MPF, the specified intermediaries and the responsible officers. Next slide, please. So in our session, we will focus more on the Hong Kong MA and the SFC requirements in this regard, because I think the new proposal will be impacting more on these two sectors. So under the existing regime for Hong Kong MA, for the functions I mentioned, some of them all of them are subject to fitness and properness requirements, but not all of them are subject to regulatory approval before they can become and take on the position. For the ones which require approval will be directors, CE, ACE, and for those which do not require approval but require notification to the Hong Kong MA will include those Section 72B managers. So I think the big the more material distinction here between getting whether you need to get approval or not from the financial institutions angle in assessing the fitness and properness, I think in any event you have to do so. But I think the only difference or the key difference is that for the ones which you require getting regulatory approval, of course, during the application process, you also need to make certain declarations to the regulators in the application form. So that is one more obligation from the financial institution in this regard, like you have to ensure that what you tell the regulator and true and accurate, otherwise there could be other implications. Next slide, please. And then for the banks which are also registered institutions, of course, there are additional requirements on the EOs and relevant individuals. Next slide, please. And then for SFC licensed corporation, Similarly, there are some functions which require approvals from the regulator, including the responsible officers and licensed representative, whereas for the other functions, even though they are subject to the fitness and properness requirement, they just need to be notified, like the directors and the manager in charge. Next slide, please. Then what are usually the key criteria in assessing whether somebody is fit and proper or competent? Usually there are quite a few aspects to consider. One is the whether the person can perform their functions honestly and with integrity. And the second aspect would be the experience of the person in assessing the competence of the person. And then the third aspect would be the financial status of the subject person. So in these assessments, usually you need to consider like the criminal records, whether the person had any convictions for fraud or other dishonesty, and whether the person may have some record in breaching any financial regulations, or they were involved in any business practices which that appear to be deceitful or oppressive, or they have other non-compliance record with any like non-statutory codes and so on. So, and apart from that, like there are other factors like whether the person, even though personally they were not subject to those investigations and so on, but they may have been involved in management of other organizations which have been subject to disciplinary actions, investigations, and so on. So for those cases, whether those cases would affect the individual per se would depend on the nature of the case and the role of the person in that company and the role of that person in that particular case. So it really depends. So these are usually the factors to consider when you do the fitness and properness assessment. And as to how you do these assessment, the SFC has not issued any mandatory step requirement per se as to how you do it. But in terms of from the Hong Kong MA angle, they have in their SPMs, they have provided some guidance on the recommended measures to do these due diligence, including like self-declaration by the subject individuals. And then you have to check the public records for evidence of the public, for the public records to see whether there is evidence of public reprimands, disciplinary actions, personal bankruptcy, and judgment debts. And then you have to obtain details of the candidate's past and present business interests, especially those which may give rise to potential conflict of interest with the candidate's proposed appointment. And then it is recommended that you obtain and verify references from previous employers or referees nominated by the candidates. And then you have to review the record and past performance of the candidate who is an existing employee. So as you can see, like the recommended measure actually includes you to obtain and verify references from previous employers or referees. But as this is just a recommended measure and it's not a mandatory requirement on the reference providing institution, whether they are going to provide it or not, then it's just voluntary. It's not mandatory. So a lot of times, as we understand in practice, a lot of the current or ex-employers may be reluctant to provide such information to the recruiting employer. Or the subject individual may be unwilling to provide such reference materials to the recruiting banks and so on. So that draws to why there will be new regime that come in to fix this loophole. Next slide, please. So now I will turn to the new proposed new mandatory reference checking requirements. For this new requirements, it is actually initiated by the Hong Kong Monetary Authority, the Hong Kong MA. They issued a consultation paper on implementation of mandatory reference checking scheme to address the rolling back apples phenomenon back in May 2020. And then after the public consultation and industry consultation, they issued the consultation conclusion in May this year. So as you may imagine, given that this initiative was proposed by the Hong Kong Monetary Authority, in terms of the scope of application, now it's proposed that it will only apply to Hong Kong regulated authorized institutions, i.e. banks, deposit-taking companies, and restricted licensed banks. So if you are a Hong Kong regulated AI and you are recruiting a new employee, and you have to do this mandatory reference checking. And for the reference providers, which are also Hong Kong regulated AIs, then it's mandatory for them to provide the reference material to the recruiting AI. And in terms of the timeline, because there are some various different operational details to be discussed and finalized by the industry working group, it is the actual implementation or effective date of the new proposal is yet to be announced. But it is expected that the IWG will provide the operational details in November later this year. So we are yet to be seen when the actual implementation date will be. Next slide, please. And then in terms of the new regime, it will be implemented in 2 phases. And for the phase 1, not all the positions at the bank would be subject to these new requirements. Only people who are falling within specific functions or roles will be subject to the new regime. And in terms of the implementation timeline, after the phase 1 is going to be implemented, it is expected that the phase 2 will be implemented in around 2 years after phase 1 is implemented. Please go back to the slide on phase 1. So in terms of the phase 1, who are actually being covered? For all AIs, it will cover the directors, the CE and ACE, and the Section 72B managers. And for the AIs who are also registered institutions, then the EOs will also be captured. And then for the AIs which also engage in insurance and MPF related activities, the phase 1 will also cover the ROs. Next slide, please. And then for phase 2, it would be expanded to cover relevant individuals if the banks are conducting SFC regulated activities, and also for banks which also do insurance and MPF activities, then the phase 2 will also capture licensed tech reps and subsidiary intermediaries. Next slide, please. And in terms of the scope of information to be covered, it would include first some generic information about the candidate, including their employment records, such as their position, business or function, and department at the ex-employer. And in terms of the more specific information to be provided or covered, it will be covering the information which could be of serious or material nature, like breach of legal or regulatory requirements relating to the banking ordinance, insurance ordinance, and so on. And incidents casting serious doubts on honesty, integrity, or matters of a similar nature, and misconduct reports filed to the Hong Kong MA, and internal or external disciplinary actions arising from conduct matters, or such other information that could affect the fitness and properness assessment. Next slide, please. So some may have some questions on various different things, like what are to be regarded as investigation, what are to be regarded as reportable internal disciplinary actions, and what are to be regarded as reportable external disciplinary actions. From the Hong Kong MA consultation conclusion, they have given some brief guidelines as to what these are and could fall within the scope of the reporting. but actually in terms of the details, the IWG will further discuss with the industry to set out the details. So in terms of investigations, it would generally cover investigations about suspected breach of laws and so on. And in terms of reportable internal disciplinary action, it would include generally internal warnings and so on due to misconduct. And for external disciplinary actions, it would generally cover actions taken by the regulatory bodies, industry associations, and professional bodies against the individual during the course of his or her employment with the reference provider. So, and in particular, in the consultation, a lot of queries have been raised as to if the investigations are ongoing, whether this will be subject to the reporting. There are two aspects to it. One is that there could be litigation risk for the recruiting AIs to provide such information to the for the reference provider to provide such information to the recruiting AI, like whether those information are accurate, true, or there could be defamation and related litigation risk. On the other hand, if such information is not to be captured, then it seems to defeat the whole purpose of the rolling back Apple regime, the proposal. So that's why the IWG will have further consideration on these implications, and then will issue to the industry further guidelines as to what are to be covered and what are to be exempted. Next slide, please. So in terms of the duration of the reporting, it would cover trace back to 7 years trace back to 7 years. And as mentioned before, information is going to be provided. There would be a number of issues to be considered, like confidentiality issues, whether there could be secrecy obligation under the law, in particular if these are referring to regulatory investigation, like under the SFO section 378, there could be secrecy obligation that you cannot disclose information regarding certain SFC investigations. So these are issues to consider. Next slide, please. So as we mentioned, the new regime will affect both the recruiting AI and also the reference providing AI. Next slide, please. So from the recruiting AI angle, it's important that you get the consent before you do the reference checking, and then you approach the reference provider, do the internal assessment, and if there are any findings or results, you should provide the employee the opportunity to be heard. And it is being encouraged that you complete the whole process before actually onboarding the employee. Next slide, please. So what if the reference provider does not provide response in time? Based on the proposal of the the Hong Kong MA, the responding AI should provide the information within 1 month. If they do not provide the information within the set period, then the recruiting AI will be regarded as to be already discharged its obligation. And then if you offer advance the offer before completion of the MRC process, or if you receive negative information obtained after onboarding, then you have to take into consideration why you are doing so, and there must be proper justification and documentation in this regard. Next slide, please. And then from the reference provider's angle, there are also certain obligations. As mentioned, you have to provide the information within 1 month of the request. And then if you don't do so, repeatedly not do so, for example, because the reference provider is also an AI, then it may call into question. And if it's serious enough, then it will draw to the attention to the Hong Kong MA. And next slide, please. So that basically summarizes the key elements of the new proposal. Now we move to a poll question number 3. An employee is being investigated for fraud or breaches of the company's code of conduct, but the investigation only commenced after his departure. Does the company need to report this to the regulator in Hong Kong or Singapore? A, yes, there are obligations to report these events under the existing or the new regime. B, no, he is no longer an employee and there is no reporting obligation under the existing or new regime. C, it depends on the nature of the conduct and when the company finds out. So the majority of the respondent has chosen yes, there are obligations to report these events under existing or the new regime. Now we move on to the next session, which we will discuss about the misconduct reporting. Maybe I move to Eunice to speak about the Singapore regime and the new proposals.
Sure. Thank you, Grace. Okay, so I saw the responses to the poll question number 3. I think essentially, at least for Singapore, even under the existing regime, if it's a reportable misconduct, even if it's in relation to a representative who has ceased employment or has left the company, there is actually already an obligation to provide the misconduct report to the MES. So with that, I just want to very quickly actually go through some changes to the misconduct reporting regime. We are running behind time a little bit, and I do want to leave enough time for the last section on practical considerations. So for this session, I'll just walk you through just highlighting some of the key changes that will be coming into force. And in relation to the details, you can certainly have a look at the slides after this webinar. But just on this, do take note that, as you know, at the moment, there is a misconduct reporting regime for SFA, FA representatives, as well as broking staff. And there will be some changes to this misconduct reporting regime going forward. Next slide, please. So we've set out an overview of the upcoming changes. Some key points to take note of. There will be some tweaks to the scope of reportable misconduct. MES will also be setting out further guidance in relation to standards expected of financial institutions in relation to conducting investigations on any alleged misconduct. There will also be changes to the reporting templates as well as the reporting timelines, and also a new obligation for financial institutions to share a copy of the misconduct reports and update reports filed with the MES with the representative concerned. And going forward, there will also be a removal of the current requirement to submit an annual declaration. Next slide, please. So in this slide, I have actually set out, what's going to change in terms of the report scope of reportable misconducts, and the changes are highlighted in red for ease of reference. Next slide, please. In terms of reporting timeline, currently it's 14 days upon discovery of a misconduct. Going forward, the reporting timeline would basically be 21 days, running from the time an FI has reasonable grounds to believe that a misconduct has been committed. So in practical terms, this could be in the course of an investigation, or it could be at the end of the conclusion of an investigation, depending on the progress of the investigation and outcome. But essentially, the test is really the time starts running from the time you have reasonable grounds to believe that a misconduct has been committed, at which point you do need to submit a misconduct report. And do take note that there will be a new investigation report that will need to be submitted to the MES as well. And these templates are available in the annex to the response to the consult paper, which you can have a look at. And then, as you know, currently, if there are any updates to the misconduct report, you do need to file that update with the MES. The requirements will be a little bit more granular and prescriptive going forward. Basically, the obligation is for you to file an update with the MES as and when there is a significant development within 21 days from the significant development. And in terms of what significant developments are, MES has also provided some guidance in the response. So it includes things like if they've completed an internal investigation, if disciplinary action has been meted out, or if there are any changes to the outcome of the investigations or the disciplinary actions. These will all be considered to be significant developments that need to be updated to the MES. Okay, and then some enhanced standards on investigation process. This is already a requirement under the existing notice, but what MES has said now is that they do expect FIs to basically implement a holistic and fair investigation process. And essentially, this is really to enhance the standards and achieve some level of consistency across in the industry in relation to how financial institutions go about investigating any alleged misconduct by representatives. And then lastly, I also mentioned earlier that there is also a need now to, or going forward, to share a copy of the misconduct reports and update reports filed with the MES, with the representative of the broking staff. And this needs to be provided within 21 days from the time you submit to the MES. But this requirement only applies to the misconduct and update reports, but doesn't extend to the new investigation report that you'll need to file with MES. For that investigation report, you file with MES, but you don't need to share it with the representative. Okay, so moving on to the summary. Next slide. Okay, so just to sum up, do take note of changes to the list of reportable misconduct, changes in the reporting timelines, as well as the reporting templates. And of course, in terms of your investigation process, it will be advisable for you to have a look and ensure that you do actually have a proper and holistic and fair investigation process implemented internally, and that you identify the responsible persons will be responsible for overseeing the investigation process as well as the reporting obligations to the MES. With that, I will hand over to Grace to talk about the Hong Kong misconduct reporting.
Thank you, Eunice. So for Hong Kong, unlike Singapore, we don't have any new proposal in the pipeline in terms of misconduct disclosure requirements. So just to recap, for the Hong Kong MA, there are some generic requirements under the various SPMs on those dishonest fraud behavior to the Hong Kong MA. Next slide, please. And then for the SFC, as you may remember, a couple of years ago, they have issued the FAQ on informing the SFC when a person ceases to be a licensed rep or RO, and if there are some ongoing investigation and so on, then you have to report to the SFC. So, and just a reminder, under the paragraph 12.5 of the SFC Code of Conduct, there are also self-reporting requirements for any breach of laws and regulations. And the SFC has repeatedly issued a few reminders to the industry that they are emphasizing quite a lot on this. So in case there is any breach and you don't report in time, this will be one of the key elements that they will consider when making their decision. Now we move on to the next poll question. Your employee A is suspected of having committed certain misconduct. You initiated an internal investigation, but employee A suddenly resigned before completion of the investigation. Company X, a potential new employer of employee A, wishes to you to do a reference check. How would you usually handle such a situation? A, do nothing. B, provide factual reference only. C, inform company X that employee A is or was under an internal investigation which has not been completed. D, respond to company A only after the internal investigation has been completed, depending on the outcome. E, any of the above, depending on employee A's role and responsibility, the nature of the misconduct, investigation status, confidentiality matters, and potential litigation risks. And most of the audience has got the correct answer, E. Now I will pass to my employment team colleagues to share with you more about the practical consideration from the employment law angle.
So in terms of some employment law considerations, these are some practical steps and recommendations that you should take. First of all, you have to determine what type of information is is reportable and what is not. And that has already been covered by Grace and Eunice earlier. Sometimes it can be it can get very tricky in practice, particularly if some misconduct is in relation to the employee's personal conduct and not directly related to the employee's performance of his duty. And in these situations, you may actually need to seek further legal advice as needed. Secondly, employers should also consider updating their hiring and due diligence policies and determine which of the employees are in scope to ensure that mandatory reference check will be carried out as required. For new employers, they should also factor in additional time to conduct the required reference check. Employers should also implement appropriate internal controls and standards and approval process for preparing and responding to reference check requirements. Next slide, please. Okay. Data privacy issues is a key consideration for many employers, and we have already received a number of questions in relation to data privacy. From a Hong Kong data privacy law angle, employees' consent is required if you want to provide his or her personal data to another individual or another company. So it's very important to get employees' consent. The mere fact that an employee is covered by the potential new mandatory reference check regime doesn't mean that the existing employer can disclose that employee's personal data to the new employer. So the Personal Data Privacy Commissioner has also responded to the HKMA's consultation papers and set out some additional recommendations. So according to the latest consultation paper issued by the HKMA, the industry working group will set out further guidelines in this regard, and it's very likely that employees' consent will also be incorporated into the mandatory reference check forms for administrative convenience for the parties. But how about if an employee specifically informed you as the original employer that he or she does not consent to you providing reference check? Then in that case, according to the HKMA's guidelines, you should let the new employer know about this fact, and the potential new employers can make its own decision as to whether or not the new employer will still proceed to make an offer. But in that case, the HKMA's guidance is for the new employer to set up properly the justifications and why the new employer thinks that it's still appropriate to make this offer, even though the employees refused consent to having this reference check. So employers should update their HR records and policies to ensure that they can respond to a mandatory reference check. They may also need to review and update their employment contracts to reference conditionalities of satisfying requisite background checks as appropriate. So sometimes, as Grace mentioned earlier, there may be a situation where employee consents to a reference check, but the reference check results only comes after the employee received an offer, or even after an employee is already on board. So in this situation, from an employment law perspective, it may be preferable for the new employer to include some wording in the employment contracts to clarify whether or not the offer is conditional upon satisfying certain reference check. As mentioned earlier, ultimately it's a decision of the new employer whether or not to proceed with the hire, but if so, the employer should have proper documents to set out its justifications. It's also important to consider including carving out in confidentiality clauses, potentially, in particular, in settlement agreements. That can be very tricky in practice if an employee leaves after some filing some grievance, and the parties want to settle in a confidential manner. But if the employer and employee do not think about this at that stage, then the existing employers can get into troubles when new employers reach out to obtain reference check. So I will now go back to Zhao Yan, who will talk about the Singapore case on reference check.
Thanks. Okay, so the point that I wanted to share down here is very important, that with respect to reference checks, if it's not done properly, it can attract legal liability. Next slide, please. So in Singapore, we actually had a case whereby an individual sued in this case. So with respect to this case, it's very important to know that employers must exercise reasonable care to ensure that any facts and opinions stated in the reference are true, and that if they're given, they cannot be misleading, they cannot be unfair, and that you must disclose any information and not withhold any information to render anything disclosed incomplete, inaccurate, or unfair. In this case, that the AXA had actually disclosed certain information, but they did not disclose the whole facts. And when the new potential employers had asked AXA to provide more, they basically ignored them. So as a result, these new potential employers drew an adverse inference. And as a result of that, Mr. Ramesh had suffered some loss as a result. So it's very important that if you're going to do a reference check, we have to do it properly and not cause in a scenario whereby it can be viewed as being unfair to the individual. So this is quite a seminal case, and this should guide, the principles inside should guide you with respect to carrying out all these reference checks. Thank you.
Now we go to the final poll questions. So the question is, who in your organization will be responsible for handling reference check requests? A, HR, B, legal and compliance, C, the employee's immediate manager, and D, a combination of relevant department. You have 15 seconds to answer the poll. Okay. Oh, that we also received some additional E. No one is doing here. Address these. I think there's no one correct answer, but we note that many of you chose a combination of the relevant departments. This question is not a legal question; it's just a survey to see who will be taking care of these type of reference check requests. So I'm aware that we are very close to the end of our session, and we note that some of you have already sent us some questions, and we have answered those. And if any of you think that you still have additional questions, please feel free to reach out to us, and we will try to offer assistance as much as possible. So thank you all for your participation today. We hope that you find the presentation valuable. Your feedback will be greatly appreciated, so please click the link in the chat to share your thoughts. And as I mentioned earlier, please feel free to contact us with any additional questions. Take care and have a nice day, everyone.
Thank you. Bye-bye.
Thank you.